Good day. This arbitration is now in sessions. Before I start, let me introduce myself first. My name is Noala Fatiha and this is my colleague Hayu Muhammadah. We are the appointed arbitrator for this dispute involving a reported non-compliance construction material. Claimant, you may proceed with the case overview first. Please focus on the cases of the non-compliance and contractual obligations.
Thank you, respected arbitrators. The basis of our claim is the respondent's fundamental failure to comply with the contract specifications, leading directly to demonstrable defects and financial loss. The contract explicitly required the use of imported tiles. Despite this clear instruction, the respondent, without seeking or obtaining any approval, stubbornly proceeded to use cheaper, non-compliant local materials. The direct and immediate consequence of this non-compliance became apparent shortly after the handover. We now face latent defects, including widespread chipping and discoloration across the entire area. Therefore, our claim is for the full cost of rectification. This includes the demolition and removal of non-compliant tiles, as well as the subsequent purchase and installation of the originally specified imported tiles to bring the project up to the standard initially agreed upon. Your Honour, the core of our argument is simple. The respondent was contractually bound to deliver what was specified, not what was convenient. We have submitted evidence Exhibit 1, attaching specifically to PWD Form 203A, General Conditions of Contract. The evidence is explicit under Clause 10A. It stipulates that the respondents shall adhere strictly to the materials, standards and specifications detailed in the bills of quantities and drawings. Our evidence clearly demonstrates a deviation from these specified requirements, substituting lower grade materials which fundamentally compromise the project's integrity. The contract demands strict adherence, but near substantial compliance. The respondent was legally bound to use specified products. The respondent's deviation from the specified materials and standards is a clear breach of the binding agreement.
Thank you, claimant. Respondent, you may now present your introduction. Please address the allegations and provide your defense.
Thank you, Your Honour. We do not dispute the substitution, which was necessary due to significant global supply chain disruption that made the specified imported tiles unavailable within the required time frame. We therefore use locally sourced tiles of the same design, size and specification as stated in the contract to ensure time delivery. This decision was taken to avoid delay to the project completion and the imposition of liquidated asset damage.
Thank you, respondent. Can the claimant confirm the substitution evidence specify the required material standard?
We do not agree, Your Honour. Supply chain shortages do not excuse non-compliance with the contract. Supply chain issues, while challenging, do not automatically permit a material substitution without following the formal contractual procedure for change, instruction or material variation. Under Clause 10F, any substitution of materials require prior approval through formal contractual procedure. However, the respondent proceed the construction with the material substitution without any instruction or approval from the SO. Such an authorized substitution constitutes a breach of contract, regardless of the supply chain challenges.
Thank you, claimant. Respondent, you may give a short response from your side.
Thank you, Your Honour. The work including the installation of local tiles were inspected by the superintending official prior to the issuance of the certificate of practical completion. The tiles were fully visible and formed part of the completed work during those inspections. No instruction, objection or directive was issued to remove, replace or vary the tiles. Following the inspection, the certificate of practical completion was issued. We therefore reasonably understood the work, including the tiles were accepted as complying with the contract requirements.
Thank you, respondent. Claimant, can you provide a brief objection?
Thank you, Your Honour. Our next argument rests on a fundamental breach of contract, the unauthorized substitution of specified materials by the opposing party. The respondent has proceeded with an unauthorized substitution of materials without seeking or obtaining prior written approval from the SO. This is a direct violation of provisions in the Form 203A under Clause 5.2 under SO instructions. There are no written nor verbal instructions by the SO that allow the substitution to use the local tiles. Furthermore, the fact that the tiles only started shipping and discarding after handover is the discovery of the damage. This happened after the start of defects liability period. Under clause 35.1 and 36.1 explicitly mandates the respondent should prove the quality of materials and test the materials according to the standards stated in the contract. By this fact, the respondent has failed to inform the substitution and no proof of testing, ultimately undermining the quality control framework of the project.
Thank you, claimant. Respondent, you may also provide a brief objection.
Respected arbitrator, we think the claimant has not adequately measured or supported the loss that have stated. A straightforward claim for the damage without supporting document does not satisfy the legal requirement for the damage. Even though we should be in charge of the task, we believe the acceptable repair work should be only appropriate remedy. The cost of complete replacement would be unaffordable and the employer might suffer a loss during the repair.
Thank you, respondent. Now, claimant and respondent, please give your closing submission before I conclude these proceedings.
May I start first, Your Honor?
Yes, you may.
The respondent non-compliance directly caused defects in the works, namely chipping and discoloration, resulting in loss to the SO and the employer. Due to these defects, rectification and replacement works are necessary to restore the works to the contractual standard. In accordance with clause 48.1, the claimant seeks to recover the full cost of rectifying the defects and replacing the non-compliant tiles with the originally specified imported tiles.
We acknowledge and accept the claim. Respected arbitrator, however, we are only able to offer repair or replace of the broken tiles in the effect area only. This is a reasonable and acceptable approach to limit for the loss. It is the employer responsible to minimize the loss, rather than continue to request major repair without first allowing an opportunity for repair.
Thank you, respondent and claimant. With the final clarification from both parties, now I will conclude these proceedings. Based on the evidence submitted and the specific clauses cited, I find that although the respondents had genuine supply issues, they failed to obtain approval from the superintending officer to substitute the material. This is a clear violation of PWD Form 203A. Furthermore, the claimants reports that this unauthorized substitution will directly cause physical defects. Therefore, I make a decision in favor of the claimant.
The tribunal orders is for the rectification of work. The respondent is ordered to replace the local tiles that do not comply with standard with the material originally specified in the contract at their own cost. For their recomposition, the respondent must pay for any financial loss caused by the cracking and discoloration of the materials. And lastly, for the compliance in future of both parties, claimant and respondent, all work must fully comply with the contract specification unless a formal change order is issued.
Having ruled in favor of the claimant, the respondent is ordered to replace the non-compliant local tiles with the originally specified materials and pay for all resulting damages at their own expense. As the party in breach of contract, the respondent must absorb all labor and material costs associated with this rectification without additional payment. This concludes our arbitration session.